If understanding your rights clearly, instead of just vaguely, is something that matters to you, I'd really appreciate it if you hit subscribe before you go, because that's exactly what this channel is built around, one real, specific legal topic at a time, explained in plain language without the unnecessary complexity. It genuinely helps more than you'd think, mostly because it tells me this kind of plain language legal content is actually reaching the people who need it, which is the entire point of doing this in the first place. All right, that's the ask. Let's keep going. Your phone buzzes. You're in the middle of something, maybe driving, maybe just standing on a sidewalk minding your business, and an officer approaches and says something that sounds almost casual, almost conversational, something like, "Can I see your phone for a second?" And in that exact moment, before you've even processed the full sentence, a decision is already forming that most people get completely wrong, not because they're careless, not because they don't care about their rights, but because nobody ever sat them down and walked through what that request actually means legally, what handing over your phone actually gives away, and what the law actually says you're required to do, versus what officers are simply hoping you'll do voluntarily. Here's what I want you to walk away from this video knowing, cold, without having to think about it under pressure. Your phone is one of the most legally significant objects you carry with you every single day, and the protection it carries is far stronger, far more specific, and far more deliberately constructed than most people have any idea. The Supreme Court has weighed in on this directly. Congress has passed laws that touch it. Courts across the country have spent years working out exactly where the lines are. And the gap between what the law actually requires and what most people assume they have to do in the moment an officer asks to see their device is genuinely enormous, enormous enough to matter in ways that can follow someone for years. Before we get into exactly what's protected, what's not, and what the specific words you need to know cold in the moment actually are, if you want to understand your rights, instead of guessing and hoping for the best, the next time someone in a uniform asks to look at your screen, subscribe right now, because this is exactly the kind of preparation that turns a high-pressure moment into something you can handle clearly, instead of something that catches you completely off guard. Quick note before we start. This is legal education and commentary, not legal advice for your specific situation, and some details shift state to state and case to case. But the core principles we're walking through here are grounded in constitutional law and landmark Supreme Court decisions that apply broadly across this country. Let's get into it. Let's start with the most important legal event underlying everything in this video, the single case that changed the entire legal landscape around phones and police. Because if you understand this one decision, you understand the foundation everything else is built on. In 2014, the Supreme Court of the United States decided Riley v. California, and the decision was unanimous. 9 justices, across every ideological line that exists on that court, agreed on the same thing. Police generally cannot search your cell phone without a warrant, even when they've lawfully arrested you. Even in that moment, even when you're already in handcuffs, even when the phone is physically in their hands because it was on your person when you were taken into custody. It's interesting, honestly, how often variations of this general subject keep coming up, across completely different specific situations, over and over. I think that's because the underlying pattern is more universal than people initially assume. A moment of pressure, a question that sounds simple but carries real legal weight, an instinct to just go along with things smoothly rather than pause and think it through. That basic shape shows up across an enormous range of otherwise completely different situations, which is exactly why understanding the underlying pattern, rather than just memorizing one specific scenario, ends up being so useful. Once you see the shape clearly in one context, you start recognizing it everywhere else too. All right, let's dig into today's specific version of that pattern. Custody. Searching through its contents requires a warrant. That's the baseline. That's where we start. And if you walk away from this video remembering nothing else, that's the thing worth carrying. The court's reasoning in Riley is worth understanding specifically because it explains why phones are treated differently from almost every other object you might be carrying. Under an older legal doctrine called the search incident to arrest exception, officers who have lawfully arrested someone have generally been allowed to search the physical items found on that person at the time of arrest, things like wallets, bags, papers, items in pockets, without needing a separate warrant, because the logic was that this kind of search served legitimate purposes, like ensuring officer safety and preventing destruction of evidence. And for decades, that doctrine was applied to whatever was physically on a person when they were arrested. Then smartphones happened, and the court in Riley looked at what a smartphone actually contains and said, clearly and directly, that applying the search incident to arrest exception to the contents of a cell phone is a categorically different thing, because a cell phone isn't just an object. It's a window into an entire life. It contains photos, messages, emails, location history, financial information, medical information, browsing history, contacts, call logs, and layer after layer of deeply personal data that has no real comparison to a wallet or a set of keys or a notebook. The court said, in language worth actually sitting with, that a cell phone search would typically expose to the government far more than the most exhaustive search of a house, and that the fact that technology now allows an individual to carry such information in his hand does not make the information any less worthy of the protection for which the founders fought. That sentence matters. A phone in your pocket carries stronger protection than most people imagine, because the highest court in the country looked at what's actually on a modern phone and decided it deserved it. So let's build from there, because Riley established the principle, but a lot of people still have genuine questions about how it works in practice, specifically about what police can and can't do at different stages of an encounter, and specifically about what you are and aren't required to do when an officer asks to see your phone. Let's start at the very beginning, the scenario that probably applies to more people than any other. An officer approaches you, maybe during a traffic stop, maybe while you're walking somewhere, maybe because of some incident nearby, and they ask, casually or directly, to look at your phone. No arrest has happened, no warrant is being produced. They're simply asking, what do you do? The answer starts with understanding that this request, in this form, without a warrant attached to it, is a request for your consent. That's all it is. It's not a command. It's not a legal order. It's not something you've been obligated to comply with by any statute, any court ruling, or any amendment to the Constitution. It is a request, and like any request without legal compulsion behind it, you are allowed to say no. Calmly, clearly, and without providing a reason, because you don't need one. The right to decline a consent search, including a consent search of your phone, is among the most clearly established rights in this area of law. You can simply say, I don't consent to a search of my phone. That sentence, those 9 words, does more to protect you in that moment than almost anything else you could say or do. Now I know what's going through the heads of people watching this, because it goes through everyone's head the first time they really sit with this. And it's a completely understandable instinct. If I say no, doesn't that make me look guilty? Doesn't that make things worse? Won't the officer get more suspicious? Won't they find a reason to make my life difficult? These are real concerns, and they deserve real answers. Let's address them directly. First, legally, declining a consent search cannot be used as evidence of guilt. Courts have been clear on this. The fact that someone exercised a constitutional right is not, by itself, probable cause for anything. An officer cannot arrest you for declining a phone search. An officer cannot legally justify further action purely on the basis that you asserted a right you're allowed to assert. That's the legal reality, and it's worth holding on to, even when the emotional reality of standing there, being looked at by someone in uniform, makes everything feel higher stakes than it logically is. Second, practically, here's the thing worth understanding about consent searches specifically. Officers ask for consent precisely because they don't already have the legal authority to conduct the search without it. If they had probable cause, they'd be talking about a warrant, or they'd be invoking an exception. If they're asking nicely and waiting for your answer, it's because your answer matters, and that means your no matters just as much as your yes would. The ask itself tells you something important about where the legal footing actually is. Third, and this is the piece that probably matters most for people watching this, what's on your phone, and what connections, what messages, what images, what locations, what searches might be discoverable from what's on your phone, almost certainly goes further than you've thought about in the 3 seconds between when the request is made and when you feel pressure to respond. Even if you haven't done anything wrong, even if there's nothing on your device you'd describe as incriminating, a sophisticated search of a modern smartphone touches things you've forgotten are there. Apps that logged your location at particular times, messages that reference people or places connected to something you had nothing to do with, search histories that look strange out of context, financial information that raises questions, photos with metadata attached. You don't need to have done something wrong for a search of your phone to create complications, and that's exactly the reason the law built in the protection it did. Let's talk about what changes when an arrest has been made, because this is where a lot of confusion lives. and it's worth being precise here. After Riley, the rule is clear. Even following a lawful arrest, officers cannot search the contents of your phone without a warrant. They can seize the phone, meaning they can take it into their physical possession as part of the arrest, but they cannot scroll through it, cannot open apps, cannot read messages, cannot view photos, cannot access call logs, none of it, without getting a warrant from a judge first. The phone can sit in an evidence bag, physically in police custody, while officers go get the warrant they need to actually look at what's on it. That's the law. The seizure and the search are two separate events, and only one of them can happen at the moment of arrest without judicial authorization. This matters enormously, and here's why practically. If you're ever in a situation where you've been arrested and officers are holding your phone and asking you to unlock it, or are asking for your passcode, or are asking you to place your finger on the fingerprint sensor, understand that these are all requests aimed at giving them access to content they would otherwise need a warrant to reach. The request for your passcode is a request for your consent to conduct a search. The law says they can't conduct unilaterally, and your rights around that request are both real and worth knowing. Let's talk about the passcode question specifically, because this is one of the places where the law is still developing and where the specifics matter enormously. The Fifth Amendment to the Constitution protects you from being compelled to be a witness against yourself, which in practice has been interpreted to mean you cannot be forced to provide testimony that incriminates you. The question of whether your phone's passcode falls within that protection has produced genuinely different results in different courts, and here's why. Courts have generally treated the act of providing a passcode, a sequence of numbers or letters that exists only in your mind, as something closer to testimony, because it requires you to convey something you know, and compelling you to convey knowledge that incriminates you sits uncomfortably close to the kind of compelled self-incrimination the Fifth Amendment was built to prevent. So in many courts, in many circumstances, an order to provide your passcode verbally has been treated as something that bumps against Fifth Amendment protection. Biometrics are a different and more complicated story. A fingerprint, a face, your iris, these are physical characteristics rather than knowledge you're conveying, and courts have been more divided on whether compelling you to use one of these to unlock a device falls within Fifth Amendment protection. Some courts have said yes, it's still testimonial in relevant ways. Others have said no. Using your fingerprint is more like a physical act than a communicative one, similar to being compelled to provide a blood sample, and therefore doesn't carry the same protection. This is genuinely unsettled law, in a way that the passcode question is slightly less unsettled, and it means the answer to, do I have to press my finger on my phone to unlock it for police, is not uniform across the country. What is consistent is that if you're ever in this situation, the right move is to clearly and calmly say, I'm invoking my Fifth Amendment right, and I'm not consenting to any search of my phone, and I'd like to speak with an attorney. That's the sentence. Say it clearly. Don't explain it further. Don't negotiate it. Just let it stand and stop there. Let's talk about what happens when officers do have a warrant for your phone, because this is where the legal picture shifts meaningfully, and it's worth understanding exactly what a valid warrant actually means and what it doesn't. A valid warrant for your phone needs to come from a judge, not from an officer's say-so or from a piece of paper filled out without judicial authorization. It needs to specify what's being searched for, meaning there should be some description of the particular evidence officers are looking for, so that the search isn't simply a license to scroll through everything indiscriminately, looking for anything at all. And it needs to be based on probable cause, meaning there's a specific, articulable factual basis, not just a general suspicion, for believing evidence of a crime will be found in the place being searched. If officers present you with what they say is a valid warrant for your phone, ask to read it. Look at whether it's actually signed by a judge. Look at what it actually says it's authorizing officers to look for and where. A warrant that says officers can search your phone for evidence of financial fraud does not, by itself, authorize officers to scroll through your personal photos unrelated to that investigation. A warrant that names a specific app doesn't necessarily authorize reviewing every other app on the device. The scope of the warrant matters, and stating clearly, I understand you have a warrant and I won't physically interfere with you executing it, but I want to note for the record that I don't consent to any search beyond what that warrant specifically authorizes, is both legally meaningful and entirely appropriate to say in the moment. That sentence preserves your ability to challenge, later, whether officers stayed within the boundaries of what the warrant actually allowed. And challenges like that have real consequences for whether evidence obtained during that search can actually be used. Let's talk about the cloud, because this is a piece that a lot of people don't think about until it's too late to matter, and it's genuinely important in the context of phone searches. When officers get a warrant for your phone, what exactly are they getting a warrant to search? The physical device, meaning the data stored locally on the hardware, is one thing. The data stored in cloud accounts connected to that device, your email account, your cloud photo backup, your messaging app's server-side backups, your cloud storage, that's potentially a different thing, subject to different legal frameworks and different warrant requirements. The Stored Communications Act is a federal law that governs how law enforcement can access data stored by third-party service providers, like tech companies running cloud services. And it has its own set of rules about what kind of legal process is required and when notice to the account holder is or isn't required. This is a genuinely complicated area of law that has been evolving rapidly as more and more of daily life moves onto servers rather than sitting locally on devices. And the practical takeaway for most people is simply this. If officers are holding your phone and accessing your cloud accounts through it, they may well need separate legal authority beyond whatever authorizes searching the device itself. And "I don't consent to any search of my cloud accounts or any accounts accessible through this device" is a legitimate and meaningful thing to state clearly in that situation. Let's talk about border crossings and airports specifically, because this is one of the situations where the phone search question works significantly differently, and it's worth understanding why before you ever find yourself in that situation. Courts have recognized something called the border search exception to the Fourth Amendment's normal warrant requirements, and it's based on the idea that the government has a particularly strong interest in controlling what and who comes in and out of the country at its borders. Under this exception, border officers have generally been allowed to conduct searches at ports of entry, including international airports, without the probable cause or warrant that would be required elsewhere. For a long time, this exception was applied to physical items crossing the border: bags, vehicles, cargo. And then smartphones became ubiquitous, and the question became what exactly the border search exception allows when it comes to the contents of a phone. Different federal circuits have addressed this differently, and the law here is still evolving in ways that create real uncertainty depending on where exactly you're traveling. Some courts have held that border officers can conduct what's called a basic or manual search of a phone, meaning looking at what's visually accessible on the screen without specialized tools, without any suspicion at all, but that a forensic search, meaning using specialized equipment to extract and analyze data that isn't immediately visible, requires at least some level of suspicion. Other courts and government policies have taken different positions on exactly where those lines fall. What's clear is that the strong warrant requirement established by Riley applies with less force at the border than it does in ordinary domestic situations, and if you're crossing an international border, the legal reality around your phone's contents is genuinely different from what it is during a traffic stop in the middle of the country. This doesn't mean you have no rights at the border. You can still decline to provide passwords or passcodes to border officers, though doing so may result in your phone being held or you're being detained for extended secondary screening, and those are real consequences worth thinking through in advance. You can state clearly that you don't consent to a search and that you're invoking your rights. But understand that the legal framework operating at an international port of entry is different enough from the domestic framework that the same approach requires more nuance, and if you travel internationally regularly, it's worth understanding your specific situation in more detail than this video alone can give you. Let's talk about the situation that comes up for a lot of people that isn't quite any of the scenarios we've covered so far. An officer asks to see your phone, not to search through its contents, but to look at a specific thing. A photo you might have taken, a message someone might have sent you, a location record from earlier that day. This kind of targeted request still runs through the same framework, because handing over your phone so someone can look at one thing rarely, in practice, means they look at only that one thing. The moment your unlocked phone is in someone else's hands, the scope of what's accessible expands dramatically, and the practical reality of "just let me see this one thing" often ends up meaning something far wider than the framing of the initial request suggested. The right approach here is the same: I don't consent to a search of my phone. If you want to be more specific about the framing of the request, you can say, "I understand you're asking about something specific, but I'd rather not hand over my phone, and I don't consent to a search." If what they're actually after is something you genuinely want to share voluntarily, there may be ways to do that without handing over the device itself, but doing it with any kind of legal awareness means understanding exactly what you're agreeing to and making an active, informed choice rather than simply going along with momentum. Let's talk about one more scenario before we get into the specific language you need to have ready, and it's this. What happens if you're a witness to something, not a suspect, not involved in any way you're aware of, but someone who happened to be in a place where something happened, and officers ask to see your phone because you might have captured something relevant on video or in photos? This is a situation where a lot of people feel like declining would be obviously wrong, almost selfish, and it's worth addressing directly because the instinct to help is genuinely different here than the instinct in other scenarios. You can choose to share relevant footage voluntarily. That's entirely your decision to make. But it's worth understanding that doing so by handing over your unlocked device is categorically different from doing so by selecting specific content to provide through an attorney, through an official evidence process, or through a carefully limited consent that specifies exactly what you're making available. If you have footage of something genuinely important and you want to help, there are ways to do that without opening your entire device to an unlimited search, and knowing that those options exist is worth something. You can say, "I'm happy to cooperate with your investigation, and I'd like to do that in a way that's appropriate," which for me means talking to an attorney first about how to make any relevant content available properly. That's a cooperative statement that doesn't require you to hand your phone over on the spot. And in most situations involving witness footage rather than investigation of you personally, officers are genuinely interested in the content rather than insisting on immediate physical access to the device. Now let's get into the specific language, because I want you leaving this video with actual sentences ready to go, not just a conceptual understanding that dissolves under pressure when an officer is standing 3 feet away and waiting for an answer. When an officer asks to see your phone during any kind of encounter and there's no warrant involved, the first thing you say is, "I don't consent to a search of my phone." Say it clearly. Say it without apology, without hedging, without a long explanation, without anything attached to it that might muddy the waters about what you actually said. 7 words. Clean, clear, done. If the officer pushes back and says it'll only take a second, or that they're just trying to help, or that cooperation would make things go faster, your response is, "I understand, and I'm not trying to be difficult, but I still don't consent to a search of my phone." The tone here matters. Warm, respectful, clear, and firm. Not aggressive, not apologetic in a way that backs away from the substance, just consistent. Repeating the same thing calmly is not escalating, it's simply being clear. If the officer says that refusing makes you look suspicious, your response is, "I understand that's how it might seem, but exercising a constitutional right isn't evidence of anything, and my answer is still no on the search." If you've been arrested and officers are asking for your passcode or asking you to unlock the device, the sentence is, "I'm invoking my Fifth Amendment right, and I'm not consenting to a search of my device. I'd like to speak with an attorney." And then stop. Do not say more. Do not explain further. Do not try to talk your way through the complexity of the Fifth Amendment in the middle of an arrest. Just those 2 sentences and then silence, which you are allowed to have. If officers present what they say as a warrant for your phone, the sentences are, "I'd like to read the warrant, please." Then, once you've read it, "I understand you have a warrant and I won't physically interfere with you executing it. I want to state clearly that I don't consent to any search beyond what the warrant specifically authorizes." That's it. Both sentences matter. The first one matters because physically resisting a valid warrant is a separate problem you don't want to create for yourself. The second one matters because it preserves your ability to challenge the scope of the search afterward. If you're at a border crossing and officers are asking to search your phone, the sentence is, "I don't consent to a search of my phone or any accounts on it, and I want that noted." Understand that this may not stop the search the way it would in a domestic setting, but stating it clearly and having it on record matters for what comes after. Let's talk about what happens after the encounter, because just like with a traffic stop or a knock at your door, what you do in the minutes and hours immediately following this kind of interaction matters more than most people expect. Write down or record everything you can remember as quickly as possible. The exact time, where you were, which officer or officers were present, badge numbers or car numbers if you caught them, exactly what was said, exactly what was asked, whether any search happened, and if so, what specifically was looked at or taken, whether a warrant was presented and what it said. Memory fades faster than feels possible in the moment, and if any part of this encounter ends up mattering later, a contemporaneous record of what actually happened, in your own words, written down close to the time it occurred, becomes a genuinely important document. If your phone was searched, whether with your consent or without it, whether pursuant to a warrant or not. Speak to an attorney as soon as possible, because the question of whether that search was lawful, whether the warrant was valid and properly scoped, whether any evidence discovered in the course of it can actually be used, all of that has real answers that can be evaluated, challenged, and potentially litigated, but only if you know what happened, documented it carefully, and brought it to someone equipped to analyze it properly. This is not a decision to make on your own, based on how the encounter felt in the moment. Let's talk about a related but distinct issue that deserves its own careful walkthrough, which is what happens when officers don't ask to search your phone, but instead ask you to show them something specific on it, or ask you to use your phone to provide information during an encounter, and whether the act of using your phone in response to that request creates any issues of its own. If an officer asks you to look something up or pull up a specific document or image, and you do so, and hand the phone over to show them, you've essentially just consented to whatever they're able to see while holding the device, and the lines around what's accessible in that moment can be blurry. The safer approach, every time, is to keep the device in your own hands and hold it up rather than handing it over. Or to simply say, "I'd rather not pull anything up on my phone right now." Maintaining physical control of the device for as long as possible matters, because the moment someone else is holding your unlocked phone, the scope of what's accessible expands far beyond whatever they said they wanted to look at. Let's talk about digital privacy more broadly in the context of law enforcement encounters, because the phone question doesn't exist in isolation. It's connected to a broader set of questions about how much of your digital life officers can access through different legal avenues, and having some understanding of that broader landscape helps the phone-specific rules make more sense. Beyond the device itself, law enforcement can often seek records held by third parties, tech companies, service providers, social media platforms, through legal processes that are separate from anything they need from you directly. This is sometimes called the third-party doctrine, which is the legal principle that information you've voluntarily shared with a third party, like a phone company or an email provider, may carry reduced Fourth Amendment protection compared to information you've kept entirely to yourself, because by sharing it with a company, you've in some sense voluntarily disclosed it. The Stored Communications Act provides some statutory protections on top of this, requiring certain kinds of legal process before providers can hand over content. But it doesn't fully replicate the warrant requirement in all circumstances. And the result is a complicated patchwork of protections that varies depending on exactly what kind of data is being requested and from whom. The practical implication for most people is that the protection you have over the contents of the phone in your hand is stronger than the protection you may have over records held by the companies whose services you use. And that's worth understanding as a general principle, even if the specific details are complex enough to require legal counsel in any concrete situation. Let's talk about workplace situations specifically, because this comes up more than people expect, and it works differently than the scenarios we've been discussing. If you're at work and your employer has provided you with a company phone, your expectation of privacy in the contents of that device is generally significantly reduced compared to your personal device, because you're using company property in the context of an employment relationship that typically comes with policies about acceptable use and employer oversight. Officers seeking content from a company device may be able to access it through the employer rather than through you personally. If you're using your personal device for work purposes, things can get more complicated, particularly if your employer has any kind of mobile device management software on the device. And understanding what exactly is on your personal device and what access your employer has to it is worth sorting out in advance of any situation where it becomes relevant. Let's talk about something that sits at the intersection of this topic in everyday practical life, which is the question of what to do before any encounter ever happens, in terms of how you set up your device, what you protect, what you understand about what's on it. This is less about being paranoid and more about being thoughtful, the same way you might think in advance about where you keep important documents or who has a key to your home. Strong device encryption, which modern smartphones generally have enabled by default, means that without your passcode or biometric authentication, the physical device is much harder to access even if it's in someone else's hands. Understanding your device's lock settings and making sure they're properly configured is a basic step that costs nothing and matters in exactly the scenarios this video covers. Understanding what cloud backups your phone is making and where that data is stored gives you a clearer picture of what's actually accessible and where if a legal process is ever directed at your accounts. Knowing what apps you have and what data they contain, what your messaging apps store and where, what your email client downloads locally, what your Photos app backs up automatically, is simply being informed about what you're carrying around with you every day. None of this is about hiding anything or preparing for a life of crime. It's about understanding what you actually have and what the legal framework around it actually is. The same way understanding what your lease says or what your insurance covers is simply being a reasonably informed adult in a world where these things matter. Let's talk about the emotional reality of this specific scenario, because unlike some of the other situations we've covered, having a police officer ask to see your phone has a particular kind of vulnerability to it that deserves to be acknowledged directly. Your phone is genuinely intimate in a way that few physical objects in your life are. It holds conversations you've had in confidence, images of people you love, records of where you've been and when, searches you've made when you were scared or confused or just curious, financial information you'd never hand to a stranger, health information you've shared with no one. The thought of someone else scrolling through that, even someone doing it as part of a legitimate legal process, even someone with the best intentions, touches something that goes beyond just legal principle. It's personal, in a way that makes the instinct to protect it feel right, even when you can't immediately articulate the legal framework behind that instinct. The law, in Riley, recognized exactly that. The court didn't treat phones as just another object. It looked at what phones actually contain and built a doctrine that takes that content seriously. And the preparation this video is encouraging, knowing the framework cold before you need it, having the sentences ready before the moment arrives, is about making sure that when you're standing there feeling the pressure of an unexpected ask, you have something more reliable than a half-remembered sense that you have rights, which dissolves under pressure, and instead have a clear, specific understanding of exactly what those rights are and exactly what you need to say to invoke them. Let's talk about one more scenario that's worth specific attention, because it comes up regularly and produces a lot of confusion. And that's the situation where someone else's phone is involved in an investigation, and officers approach you, not as the owner of any device being sought, but as someone who might know where a person is, what they're doing, or what's on a device that belongs to someone else. In this situation, you're being asked as a witness rather than as a suspect, and the same general principle applies. You are not obligated to answer questions. You are not obligated to assist in locating or accessing a device that isn't yours, and you are not obligated to reveal what you know about another person's digital activities or whereabouts. "I'd rather not answer questions without an attorney" is a complete sentence that applies as fully to witness-style questioning as it does to any other kind. And feeling like you're being helpful by talking through everything you know is often the instinct that leads witnesses into the most complicated positions. Let's also address something that comes up frequently as a misconception, and that's the idea that if you have nothing to hide, you have nothing to protect. This framing sounds intuitive, maybe even generous in spirit, and it's worth dismantling clearly because it misunderstands what privacy actually is and what it actually protects. Privacy isn't primarily about hiding wrongdoing. It's about maintaining a zone of personal life that isn't subject to examination by anyone with sufficient authority and curiosity to look. It's about having conversations, thoughts, searches, and relationships that are yours, without being subject to review. It's about the principle that a free society needs people to be able to move through the world, including digitally, without every aspect of their lives being legible to the government at will. Even if everything on your phone is completely innocent by any standard imaginable, the principle that your phone's contents are yours and require legal authorization to access isn't something that only matters to people with things to hide. It's something that matters to everyone, because the alternative, a world where the contents of every phone are available to anyone with a badge and a request, is a meaningfully different kind of world than the one the Fourth Amendment was built to protect. Let's talk about what happens if you made a mistake, because this comes up in this topic the same way it comes up in every topic we've ever covered, and handling it needs its own clear walkthrough. If you already handed over your phone before you knew any of this, if you unlocked it when asked, if you provided your passcode without knowing you didn't have to, you're not alone, and you're not without options. What you can't do is undo what already happened, and what you absolutely should not do is try to walk it back verbally in the moment, or attempt to explain your consent away mid-encounter. What you can do is stop from that point forward, say, "I'd like to stop answering questions, and I'd like to speak with an attorney," and then do exactly that as quickly as possible. because the question of whether what was found during a consensually granted search can be used, whether the consent was truly voluntary and informed, whether the scope of what was accessed exceeded what you actually agreed to, are all questions with real legal answers that an attorney is equipped to analyze and potentially challenge. The mistake doesn't necessarily end the story. Getting proper legal counsel as fast as possible gives you the best possible position for whatever comes next. Let's talk about a few final connected pieces before we bring this all together. Pieces that exist right at the edges of the phone search question, and that are worth knowing even if they don't come up in every situation. First, body cameras. Many officers are now equipped with body cameras, and in many departments these cameras are required to be running during certain kinds of encounters. This cuts in both directions. Body camera footage can be genuinely helpful in documenting what was said and what happened during an encounter with your phone, including whether your refusal of consent was clearly stated and acknowledged. And it's worth knowing that this documentation exists and can potentially be accessed through your attorney if an encounter becomes legally relevant later. Second, your phone's own recording capabilities. In many states, you have the right to record encounters with police in public places, and your phone is your primary tool for doing so. The irony of a scenario where an officer is asking to see your phone while you're using that same phone to document the encounter is not lost, and it's worth knowing that in most places, you're allowed to continue recording even while asserting that you don't consent to a search of the device doing the recording. The right to document and the right to decline a search exist simultaneously and don't cancel each other out. Third, if you ever hire an attorney because of something connected to a phone search or anything adjacent to it, one of the first things that attorney is likely to do is request the preservation of any relevant evidence, including the phone itself, its contents, and any documentation of what was searched and when. Evidence in digital form can be altered, deleted, or overwritten, and a timely preservation request is sometimes one of the most important early steps in any case where digital evidence is relevant. Let's bring everything together now, because I want it sitting clearly and completely in your mind before we wrap up, structured enough that you can actually hold it and draw on it under pressure, rather than just nodding along while watching and losing most of it an hour later. Your phone is one of the most protected objects you carry under modern constitutional law. Riley v. California said clearly that its contents are not subject to warrantless searches incident to arrest, and that protection extends to pre-arrest encounters where no warrant exists and officers are simply asking. Without a warrant, a request to see your phone is a request for consent, and consent is something you're fully, legally, constitutionally allowed to decline. The sentence is, "I don't consent to a search of my phone." Say it clearly, say it calmly, say it once, and then say it again if you need to, without expanding or negotiating or apologizing for it. If you've been arrested and you're asked for your passcode or asked to unlock your device, the sentence is, "I'm invoking my Fifth Amendment right, and I'm not consenting to a search of my device." I'd like to speak with an attorney and then stop talking. If officers present a warrant, read it. State clearly that you don't consent, but won't physically interfere with a valid warrant's execution. And note for the record that your non-consent to any search beyond the warrant's specific scope is on the record. At the border, understand the rules are different. State your non-consent clearly anyway, and seek legal counsel if any search happens before you know your specific rights in that context. After any encounter where your phone was the subject of a search, a request, or a question, document everything immediately and speak to an attorney as soon as you're able to. And through all of it, remember that the protection around your phone isn't there because the law assumes you're hiding something. It's there because the Supreme Court looked at what a modern smartphone actually contains and decided that it deserves the same serious, deliberate protection the framers built into the Constitution for the most intimate spaces of a person's life. Your phone is that intimate. The protection it carries reflects that. And knowing how to invoke it calmly, clearly, in the exact moment it matters, is the entire purpose of everything we just covered. Say the key sentences one more time, out loud, because saying them now in a calm moment is what makes them available instinctively later in an uncalm one. I don't consent to a search of my phone. I'm invoking my Fifth Amendment right, and I'm not consenting to a search of my device. I'd like to speak with an attorney. I understand you have a warrant, and I won't interfere with you executing it, but I don't consent to any search beyond what it specifically authorizes. 4 sentences, clean, ready, yours. If this gave you something concrete that you didn't have before today, subscribe right now, because there's more of this coming, one real scenario at a time, built to turn the moments that catch most people completely off guard into moments you've already thought through carefully, long before they arrive. Stay calm, know what the law actually says about what you're carrying in your pocket, and remember that the protection around your phone exists because the highest court in this country decided your digital life is worth protecting. It is, and now you know how. Before I let you go, I want to say one more time that understanding your rights clearly isn't a small thing, even when the specific topic feels minor on the surface. It's the difference between navigating a real situation with confidence and navigating it with anxiety and guesswork. And that difference matters more than people usually realize until they're actually standing inside a moment where it counts. Thanks for spending this time building that understanding with me today. I'll see you in the next one.